Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Massing. To my left is Judge Henry. And we are your panel for the one case we are hearing this morning. It is a DCF matter, 2022 P949. I want to remind the parties that, as you all know, since you're pros, that it is impounded, so please refer to the parties only by status. We have obviously read the briefs and looked at the record appendix, so we're familiar with the facts and the main arguments. Therefore, I would urge the parties, to the extent possible, to cut to the chase. So, Attorney Foster.
Did you call the case? Did you give the name?
Yes.
Okay, try it.
Good morning. May it please the court, I'm Attorney Catherine Foster on behalf...
Could you just angle it? It's
Sure.
Directional.
Is this better?
Yes.
Okay. Attorney Catherine Foster on behalf of the mother in this case. In 2018, mother stipulated to current parental unfitness, and in 2018, DCF presented evidence of mother's current parental unfitness. That evidence comprises the majority of the record. But in January 2022, at the time of trial, DCF was required to produce evidence to prove mother currently unfit again. But between 2018 and 2022, there is a strange and troubling gap. In the year and a half leading up to trial, there's no evidence for approximately 8 months. The court acknowledges this in what is frankly a rather bizarre finding in the middle of it, note actually in the middle of its findings. Between findings 77 and 78, quote, no testimony or exhibits document what occurred from late 2020 to mid-2021. Finding 77 leaves off in October 2020, and finding 78 picks up in July 2021, 8 or 9 months. To terminate parental rights, though, the court has to look at the time before.
We are talking about the height of COVID, correct?
Yeah, sure. Trying to remember back that far, but yeah, that was still during the lockdown. That's correct. But to terminate parental rights, the court has to look at the time before trial. And the distant past is relevant, of course, but this is the most important time period. And what makes this case so weird, and mother argues requires remand, is that the judge recognizes that there's just no information for about 8 months.
So I think we're going to hear from the department basically that this is what happens when the department can't reach the mother. And if you look at the next finding, it starts saying that they started trying to reach the mother and they didn't. And so that's inherently going to happen when the mother is really basically not available for parenting. So what's your response to that?
My response to that is that normally what happens when a parent disappears is that DCF provides monthly documentation so that the court knows that casework happened. But in this case, the most recent service plan is from June 2020. And even in July 2021, when the new social worker came on, there is testimony from mother that she didn't even know until she connected with the social worker in October that her social worker had changed again. She had been in contact with Shantae, her previous social worker. So when there's no, and then the ongoing worker at the time of trial testified about the June 2020 service plan from several years ago, that she hadn't updated it, that she didn't add anything to it, that she didn't ask mom to do any services on it or make any referrals for her during her time on the case. So, you know, this is a case where mother was communicating with her child during this time. There's evidence that even though the court's last finding about contact between mother and child is finding 101 about September 2020, that mother continued to have contact with her son virtually and by phone calls all the way up until November 2021, right before trial, when she contracted COVID and pneumonia. But there's no evidence about that contact. There's no evidence about the character, quality, or contact of those conversations ongoing between mother and her son, arguably the best evidence of current parental fitness during this time.
Weren't there a couple of findings that the son no longer wanted to be in contact with the mother?
There is some evidence to that effect, but there's also, for instance, mother's attorney discusses with mother during her testimony some dictation that the department could have introduced, where in September 2020, the child expresses that he misses his mother, and in March 2021, he says he wants to meet her in person. That's at transcript 167 and 168. So a stale statement from the child in February that's contradicted by more recent evidence, where the department could have introduced evidence during any of this time period about the content of the interactions between mother and her son, and how son responded to mother, his more current position with
Well, actually,
evidence.
I mean, isn't his more current position that he filed a brief in this matter of favoring termination?
Sure, and the attorney's representation of the child's position is absolutely entitled to weight by your honors, but it isn't evidence. And the concern is that the judge didn't have that evidence to rely on, and in particular, where she found there was no bond, but she actually overlooked, it seems, that entire 14 months of ongoing contact between mother and her son.
But at this point, tell me if I'm wrong, the last in-person contact between mother and son was May of 2019. So
That's correct.
as of next month, it'll be 4 whole years. The child will be, if memory serves me correct, 16 in September. We're only talking about a little over 2 years left before the child reaches his majority and can do whatever he wants. Based on these facts in this record, how can you say that there is evidence of a bond between mother and son?
Well, I guess my argument is that no one could, because there isn't enough evidence. I mean, there's an entire 14 months where the judge completely overlooked all contact that was ongoing. Mother's attorney tried to elicit some of that contact from the adoption worker. She said, of the most recent visit before trial in November 2021, how was it? Did it go well? And the adoption worker said, I'm not sure. I don't participate in those. The only information we have about any of those visits is that they were, quote, appropriate.
Well, did mother testify to them?
No, mother didn't. Mother testified very emotionally that she hadn't seen her son for the last 3 years or hugged him. And she became very emotional during her testimony and logged off and had to log back on.
Can I ask just a couple procedural questions? This was on as a review and redetermination?
That's
Is that, why was that? And how does that affect the standard, if at all?
Yeah, so after there is a finding of unfitness, every 6 months, or not less than 6 months, any party can bring a motion for what's called review and redetermination for the court to look again and see if the parent is still unfit. In this case, DCF brought the motion for review and redetermination, and it was allowed. And that means...
That was after mother had stipulated to unfitness as of 2018?
In 2018, yeah.
Okay.
And so at the trial for review and redetermination, if a parent moves for review and redetermination, they have some burden to show that there was a change. When DCF moves for review and redetermination, they have the burden to show most recently, currently, now, what is the evidence of unfitness? So while the judge doesn't start with a blank slate, and the judge can rely on the old information, the important information that the judge needs is the current information.
So if I'm hearing you correctly, you're saying there's no difference between this and the ordinary termination context, other than the fact that there was a past stipulation of unfitness?
It's incredibly similar because the judge can rely on, look at that old evidence. But the burden is on the department to produce current evidence of unfitness.
But it always is. It always is.
It always is, yeah.
Okay.
But in adoption of Aaron, the court talks about looking at facts that have metamorphosized, have changed, that are different since the last finding of unfitness in the last time period. And in this case in particular, the problem with the court relying on old evidence regarding this mother and this child is that not only did mother change, she was single at the time of trial, she was employed, she had stable housing, she had visited with her son regularly, virtually and by phone calls, but this 8-year-old that was removed and the child who was 10 when mother was adjudicated was now a teenager he wasn't learning to read, he was, studying and playing sports and dreaming of going to MIT. And the concerns about mother when the child was 8, there's no indications about how mother in the current context could parent a teenager and how the teenager would respond to her parenting. And those are the facts that I think adoption of Aaron would counsel us to focus on, and those are the facts that are not in evidence here. The court also, because
But so, I mean, there's in DCF's brief, I think it's DCF's brief, maybe it's this child's brief, goes through a litany, or the judges too, of 7 times after 2018, where the police had to be involved to incidents that showed the mother's instability, and there's open issues of mental health and substance abuse or substance use still, it seems, from the findings. Aren't those relevant?
well, as far as things from October 2020 are relevant, because all of those police responses end in October 2022, even though the DCF requested them earlier than that in 2021. So there weren't any after October 2020. And there are other things like the court found that mother, quote, stopped attending reviews because the social worker said, no, to my knowledge, no, mother didn't attend foster care reviews during her 6 months on the case. But the problem is there's no evidence that
I think you're right about that one. But I think you're right about that one.
Okay.
But personally, but what about but what about the open issues of substance use and mental health and domestic violence?
Well, with regard to domestic violence, mother was single at the time of trial, and since June 2020, there's no evidence of any casework involving, her seeking services for domestic violence. In particular, the social worker at the time of trial explicitly said she didn't do any casework. She didn't ask her to do services or make any referrals. So the fact that she's single is probably the best evidence on the issue of domestic violence. And as far as mental health and substances, the evidence at trial was that she was inconsistent, but still working through her issues. And importantly, for the first 8 years of the child's life, mother had the same issues, and mother parented him well. And the issue now is when he's a teenager, and mother is different and he is different, but there's no evidence about how that difference impacted mother and the child's relationship, such as it is. We don't even know what it's like right now, the content or quality of their conversations.
Is it that we don't know what it is, or there isn't any?
There isn't any evidence. We can't know without evidence. I think that's the answer.
But isn't there evidence, for example, that the mother was given certain opportunities for contact and didn't pursue them?
I think in late 2019 or maybe early 2020. But again, my focus is on the most recent year and a half, 2 years before trial, and in that time she wasn't. Or, I'm sorry, there's no evidence whether she was given any opportunity or not. There is evidence in March 2021 that the child missed her and wanted to see her in person, but that's it.
Another procedural question for you.
Yes.
You make some claims about the evidence being improperly admitted. Was there any objection to the affidavit, to the petition that was, it was Petitioner's Exhibit 1?
I don't know that there was, I don't think that there was an objection, and Sister Counsel is correct that there were no motions in limine, but I would just...
And I mean, aren't the counsel for the appellees right also that especially particularly finding 19 about that, which you say shouldn't be in there, it is about an incident at school, I think, right? Yeah. Investigator Romulus responded to Blackstone School, and Jabril reported that his mother lied to him about being stabbed, something like that. Those are all based on second-level hearsay where they identify the speaker. Isn't that admissible under adoption of Luke?
I think it's technically admissible, but I would point your honors to the purpose of civil complaints, which is to frame the issues for the judge, and in any other civil case.
But the case law on that is that affidavits, you know, you analyze an affidavit independently. It doesn't matter whether it's a pleading or not. If it's admissible on its own, it's admissible on its own. And anyway, that's the clock's
I'm sorry.
running. So.
Yeah, in this case, I think it's complicated because the pleading and the affidavit are so intertwined. In closing, I would just say that this family's been separated for 7 years tomorrow. On the eve of this tragic anniversary, Mother respectfully requests that this court vacate the trial court's decision and remand for DCF to present current evidence of current fitness for her current child. Thank you.
Counsel, thank you very much.
And as you sit down, I want to make one compliment, and this is just that your record appendix, the table of contents, is excellent. Like that's what they should all look like. It lists the documents, document with the date. It's very helpful. So thank you.
Good,
Trust
thank
me,
you.
from my colleague Judge Massing, that is high praise.
I appreciate that. Thank you.
I understand the appellees are splitting their time 9 and 6, and we will hear first from the Attorney General's office.
Good morning, and may it please the court. My name is Vanessa Lawrence, Assistant Attorney General for the Appellee Department of Children and Families. This case concerns an appeal from a decision of the Boston Juvenile Court finding mother unfit to parent and terminating her parental rights. For clarification purposes, I'll be referring to the child simply as the child. Given mother's 20-year history with the department, her well-documented history of mental health concerns and substance use issues, several incidents of domestic violence in the home, recent incidents in which police responses were required, and her reluctance to engage in services requested by the department for her action plan.
So counsel says that at the time of trial, mother was single, in stable housing, and employed. Is that something you agree with?
So the trial judge did not credit mother's testimony that she was single. The trial judge found that due to a recent police incident involving the alleged boyfriend who had been part of the initial 51A report and investigation in which the child was emergency removed, that mother's testimony that she was single and was no longer involved with this person was not credible.
What about the other two, stable housing and
Employment.
employment? What about those two?
The judge did not make any findings regarding her employment.
I'm sorry.
The judge did not make any findings regarding her stable housing and employment. In response to some of the things that Sister Counsel said regarding mother's relationship with the child, I would like to point out that there were several occasions in which mother was visiting the child for her DCF visits, in which they were ended abruptly due to mother's inappropriate behavior, or which the child requested that they be ended early due to him being uncomfortable. There was an occasion specifically for child's birthday in which mother was given specific guidelines by DCF in which she did not comply with, and when pointed out that mother was not complying with these guidelines, mother became angry and was yelling at the DCF employees, and the visit was terminated early. Additionally, regarding the relationship between mother and child. When the visits became telephone visits, child did in fact establish a code word so that if you were uncomfortable, he could end the phone conversation, and child did in fact use that code word. And at the time of trial, the child no longer wanted visitation with his mother. Circling back now.
And that was established on the record as evidence and not merely by the fact that the child is on one side of the podium or the other?
That was a finding by the judge. I don't believe that mother's testimony reflected that at trial.
So what did the judge base that finding on?
So that was finding 103.
Adoption social worker or Romaine's testimony is what it says. Finding 103.
Yes, thank you. And you're correct. That was the testimony of the social worker.
And the testimony, then the social worker did in fact testify that way?
Yes.
Okay.
And circling back to the department's burden to prove by clear and convincing evidence that mother was currently unfit, in regards to the argument that the trial judge relied on stale facts, as stated previously in review and redetermination proceedings, prior stages of the proceedings are admissible, as well as prior patterns of parental neglect are admissible to show future ability to care for the child, and that is adoption of Elena at page 33. Additionally, the court is allowed to conduct this analysis through a totality of evidence, confluence of factors that speak to the parent's ability to adequately provide care for the child. Here, the mother's failure to engage in services as requested by DCF. Those services include engagement at the Moms Project, random drug testing, submitting a substance use evaluation, submitting a mental health evaluation, consistent engagement with therapy. All of those are evidence and characteristics of parental unfitness in which the trial judge properly considered in this case.
When was the latest, you just listed a litany of, failure to comply or whatever. What is the most recent date of that?
I'm sorry?
I'm sorry. What is the date of those? You just said they made a list of all things she wasn't doing. That was as of when? Because the counsel argues that it's as of February 2017.
So in 2017 was the last substance use evaluation that mother effectively completed. Since then, mother has failed to submit any substance use evaluation, an updated one, or complying with the drug testing as required by her DCF action plan. So that is since 2017.
So was there a newer action plan that required that, or was it still just under the old plan?
So the most recent plan that we have, I believe, is in 2020, but each of Mother's action plans were consistent in what they required for services because Mother, over the years, was consistently in non-compliant or partial compliance, partial compliance with her DCF action plans. Each reiteration contained very similar requests of Mother, as I stated, to engage in the Moms Project, to go to therapy, to go to a domestic violence group, and most of which of those things she either did inconsistently or not at all.
Is Attorney Lawrence right? Attorney Foster right that actually there's no evidence that Mother didn't go to foster care reviews? I think the record, there's 3 of them, and either Mother attended or one of them, counsel attended for Mother?
I believe that's correct.
Okay. So is that a problem?
I think that that Mother's engagement with DCF was spotty. As you noted earlier, that DCF had difficulty getting in touch with Mother on several occasions, that Mother often canceled her home visits, and so communication with DCF was an issue in this case. I would like to state that the more newly developed facts that the trial judge relied on included mother's testimony at trial, including her mental health, that she was no longer taking prescribed medications. It also included that the trial judge could not verify mother's sobriety and therefore did not credit her testimony that she had been 10 years sober. At one point, mother, on the first day of trial, said that she was 6 months sober. On the second day of trial, said that she was 10 months sober. And due to her most recent substance abuse evaluation.
10 months or 10 years?
I'm sorry?
Was it 10 months or 10 years that she said she was sober?
10 years.
10 years, okay.
And due to her most recent substance abuse evaluation in 2017 that came back positive for cocaine, the judge could not credit mother's testimony there. Additionally, in regards to domestic violence in the home, mother denies that domestic violence occurred and that it affected her children. However, there are several 51A reports alleging domestic violence. Mother had a domestic violence group as part of her request by DCF in her action plan. And the court has noted that a parent's refusal to recognize or to address a partner's intentional and violent conduct can be a consideration in unfitness. And additionally, in regards to the recent police incidents, mother
Counsel, you can have 30 seconds to wrap up.
Okay, thank you. Mother has been involved in several incidents in which police response has been required, and we know by care and protection of Frank that the court is able to consider those as part of their evaluation of parental unfitness. So I would ask that this court affirm the Boston Juvenile Court's decision to find that the child is still in need of care and protection and to terminate mother's parental rights. Thank you.
Thank you, counsel. We will hear from Attorney Tierney for the child. And Attorney Tierney, if you could tilt the mic down a little.
Thank you. Although I think I speak much louder than either of my sisters, so I don't think it's going to be much of a problem. May it please the court, good morning. Attorney Sheila Tierney on behalf of the appellee child. I'd like to start off by first bringing to the court's attention what I believe is a flaw in Mom's claim that while the record is sparse between late 2020 until July of 2021, when a new DCF worker was appointed in her case, in fact, Mom testified at trial that with the efforts that the newly appointed worker from July of 2021 through trial attempted to make to Mom admitted in her testimony that she just didn't return DCF's calls. She didn't get back to them. And that can be found at the transcript on page 186. And I would also like to address Justice Massing's question about the issue of when it's a review and redetermination hearing. And this court, in a custody of a minor number 2, basically stated that the focus when the hearing is a review and redetermination hearing should be on whether there has been a metamorphosis of any of the factors that led to the finding of the parent's unfitness at the time of the stipulation, or any newly developed evidence, versus at the time of the trial of the rehearing and redetermination that would impact the biological parent's relationship with their child.
Although that sounds like a standard for when the parent seeks review and redetermination. Isn't it different when the department does?
Well, I understand, Judge, that the department still has the burden. I do believe that the focus still is on whether there's been any change in Mom's condition in terms of her issues that she was suffering from as a parent at the time that she stipulated to unfitness and at the time of the trial. And
when she stipulated unfitness, was there, I guess the DCF must have gotten temporary custody at that point, or?
So, Judge, DCF had temporary custody on an emergency basis going back to April 15th of 2016, when the child was removed because of the domestic violence in Mom's home. The department was given permanent custody of the child when Mom stipulated on May 11th of 2018.
But there had not been a TPR at that point?
No, they had not.
And so that was what, so the department's request to bring it forward was based on seeking to terminate parental rights at that point.
Exactly, Your Honor, because more than 2 years had passed, because by the time we got to trial, Mom had stipulated to unfitness in May of 2018, and then the trial was held in January of 2022. You know, there were some procedural glitches. Mom had an attorney. There was a dispute between Mom and the attorney. The attorney was allowed to withdraw on the eve of an earlier scheduled trial. So Mom effectively, Your Honors, had from April of 2016 until January of 2022, within which to try and rectify her parental failings. And
But it's still the department's burden to demonstrate those failings in that period, isn't there?
Yes, it is, Your Honor, and I believe that the record clearly demonstrates that the department did that. If you look at the issues that Mom had when she stipulated in May of 2018, she had issues with her mental health, her substance abuse, and her domestic violence. If you look at what was introduced at the trial in January of 2022, Mom still had issues with her mental health. There was testimony that both Mom's psychiatrist and Mom's therapist stated that as of November of 2021, which was just a couple of months prior to trial, Mom was inconsistent in her treatment with both the psychiatrist and also the therapist. The psychiatrist indicated to the DCF worker, and there was testimony to this effect at the trial, that the psychiatrist couldn't even determine whether Mother were taking her medication as prescribed because the medication frequently was not filled in a timely fashion. Mom testified at the trial that she wasn't taking any of her psychiatric medication. Her therapist testified that Mom had not been treating with her, and Mom only re-engaged with her as of the Friday before the trial started. In addition, on the issue of the substance abuse, there was no evidence whatsoever of whether Mom, had addressed her substance abuse problems. In May of 2018, when she stipulated, the evidence was that in the one substance abuse evaluation that Mom submitted to, which was done in March of 2017, Mom had 3 drug screens that were all positive for cocaine and alcohol. Once that happened, from that date forward, Mom absolutely refused to engage in any kind of urine screens. She refused to do any substance evaluations. And the last time that she discussed doing urines and a substance evaluation was with the new social worker in October of 2021. And Mom testified at trial that she refused to do urinalysis as of October of 2021. So Mom never provided any information from which the judge could make a determination of whether she was currently involved with substances or not. So it was reasonable for the judge to rely upon Mom's lengthy history going back 20 years.
If you can just sum up.
Thank you.
Yeah.
In summary,
Instead of summary, can I ask a question?
Yes.
Has there been a case yet by either us or the SJC about how we deal with sort of the COVID, the height of the pandemic and the absence of, in-person home visits and, all these things that had to change? Because is there, and does that change the standard? Are we more lenient or? And if not, how would you imagine, what would those cases say if we got that case? So no case that you know of?
I'm not aware of a case that talks about any change in the standard. I'm aware that there have been 1 or 2 cases that talked about whether it was sufficient for the trial to have been conducted by Zoom or by having a participant phone call in. In terms of if this court were going to address that, I think the best policy, Your Honor, would be just to continue to evaluate it on a case-by-case basis, rather than establish some kind of a blanket procedure, because as we all know, all of these cases are just so fact-specific and involve, serious constitutional rights. I don't think that this court should just develop a general rule for how it should be handled. Thank you.
Okay, thank you very much. The case is submitted. I want to compliment all three counsel on the excellent job they did, not just on the table of
appendix.
contents of the record appendix. And in terms of our complimenting counsel, it's not just on